Good afternoon. Today we're going to talk about disability law. So we're going to look at disability law under a couple different contexts. One will be initially talking about participants with disabilities. We'll also talk about some employment or some aspects where persons with disabilities and accommodations and some other sport and recreation aspects of disability law. First, with participants with disabilities. We're going to look specifically at 4 different pieces of legislation over the next chapter here. Rehabilitation Act, Individuals with Disabilities, Education Act, the Amateur Sports Act, as well as the Americans with Disabilities Act, each of which really is designed to integrate disabled persons into mainstream society in order to minimize any lack of opportunities and to increase their opportunities and abilities to be a part of normal everyday society. Section 504 of the Rehabilitation Act talks about no otherwise qualified handicapped individual shall solely by the reason of his handicap be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receivable federal assistance. We can see that the language there really does mirror the other discrimination type cases that we looked at in different types of legislation, whether it's gender or whether it's race or all these other different types of disabilities. The language and the outcomes really try to mirror each other. The Rehabilitation Act, in order to successfully pursue a claim, you have to prove that you're handicapped, you have to prove that otherwise qualified for the activity, that you are excluded solely by the reason of that disability, and that the institution receives federal financial assistance. Again, we can see a direct correlation between gender and race as we look at this act, and certainly the sections to prevail under this type of claim. So we can look at Knapp versus Northwestern as we begin to investigate this idea of disabled and how that's defined in a different aspect. Section 504, the Rehabilitation Act, requires that the defendant makes reasonable modifications. So you'll see that term, reasonable modification. So what is reasonable modification? Really depends on what the jury's looking for and defining as a societal background. It does not require fundamental modifications or substantial modifications, certainly something that may put your entire organization at risk financially. However, reasonable, when we look at reasonable in terms of a legal concept, it really is a judge or jury definition of what we think would be reasonable. The Individuals with Disabilities Education Act is a little bit different. This is focused solely on school and education. It's set to provide non-academic and extracurricular activities and services to give children with disabilities an equal opportunity for participation. When we look at these cases coming up in this section and we can compare them to the cases that we looked at in our Introduction to Constitutional Law section about giving students access to sport, certainly in terms of eligibility types of things, it's very different. And this outcome is very different because of the Disabled Education Act. One of the requirements of the IDEA is that the students, teachers, and parents develop an individualized education program for the student. And when participating in athletics is a part of that educational program, that participation then becomes a federally protected right. We looked at earlier that these rights or ability to play interscholastic athletics isn't considered a right. It's a privilege. It's not guaranteed anywhere. In fact, we have numerous regulations that limit it, whether it's by age or by GPA or a number of different aspects that we can do. However, when it's a part of your individual education program, that becomes educational nature, and that then becomes a federal right. We look at that in the Denon case, and we can compare and contrast to Sanderson and Letendre and a couple other cases that we looked at earlier this year. Ted Stevens' Olympic and Amateur Act names the USOC as a coordinator of amateur athletics in the United States for Paralympic activities as well. And as such, the USOC really has a goal of helping disabled athletes breaking down unnecessary barriers to competition and really begin supporting para athletic events throughout the nation and internationally. The ADA, the Americans with Disabilities Act, is set up to provide a clear and comprehensive mandate for the elimination of discrimination against individuals with disabilities. The ADA has three different types of areas. Title I deals specifically with employment for Americans with disabilities. Title II talks about public services. And Title III talks about public accommodations and services operated by private entities. Title I, employment. It protects individuals with disabilities from discrimination in the workplace. A little bit different than the Rehabilitation Act. Title II, public services, that no qualified individual shall by reason of disability be excluded from participation in or denied the benefits of or subjected to discrimination by any public service entity, any governmental aspect. The elements to pursue a claim here: you have to be qualified with a disability, otherwise qualified for the activity, excluded solely by the reason of disability, and discriminated by a public entity. Again, those elements are certainly reflective of the other types of discriminatory legislation that we've had, whether it's the Rehabilitation Act or whether it's discrimination by gender or by race or religion. It really is emphasizing the equivalent elements to pursue that claim. Title III is a similar aspect. Language, again, very similar. No individual shall be discriminated against basis of disability with full and equal enjoyment of the goods, services, facilities, privileges, advantages, accommodations of any place of public accommodation by any person who owns, leases, or operates a place of public accommodation. Again, this is very similar to a lot of racial discrimination language where it says if you are a private entity and you open your doors for a public accommodation. So if you're a restaurant, you're a hotel, you are a sports facility. If you are open for business, you need to be open for business to everyone. A place of a public accommodation. And the priority that the government places on this type of legislation really weighs heavily on avoiding discrimination. We looked a couple sessions ago at different criteria that can be established for a purely private entity, and we looked at those Lansdowne factors. It's going to be very limited. The language to pursue the claim, the elements are very much individual with disability, otherwise qualified, excluded solely by the reason of disabilities, discriminated by, and this isn't public entity, this is private entity that's a public accommodation. Now, much like the Rehabilitation Act, there are some exceptions to this. First is a direct threat exemption. An individual organization does not have to accommodate an individual if he poses a direct threat to the health and safety of others. For instance, you want to have a reasonable modification, and allowing somebody who's disabled, perhaps in a wheelchair, be a coach at a baseball team is encouraged. However, a first base coach is probably not the best place because of this direct threat exception, that the ball flies out from the first baseman a lot, there could be some foul balls, and the person in the wheelchair could get in the way and be a direct threat to themselves and the health and safety of others. But in a bullpen or a bench coach, batting coach, those types of places, it's very much minimized, and that would be that reasonable modification that we'd be looking for. Casey Martin versus PGA Tour certainly gets into this idea of reasonable modifications and not changing the fundamental nature of the activity. We can compare and contrast that to Kukets. Both deal with sport. One allows special accommodation for an athlete and one would not. And we look at the basis of these two different cases, that fundamental changing of the activity. What is the fundamental activity of golf? And what is the fundamental activity of racquetball is really what it boils down to in these different discussions. Feldman versus Pro Football Incorporated is a case where a disabled person is looking for tickets and seating arrangements in a professional football stadium. Title I of the American Disabilities Act, we're looking at employment. No one shall discriminate because of disability, regards of job application, hiring, advancement. Again, language that is really similar and mirrors gender and racial discrimination aspects. Who qualifies? An employer qualifies who's engaged in an industry affecting 15 or more employees working each day for each of 20 or more calendar weeks in a current or preceding calendar year. So it's not necessarily focused solely on the very small businesses and requiring people to do things, but a very large business, or certainly 15 or more employees, then that company has to be compliant with Title I of the ADA. Disability is defined as any physical or mental impairment that substantially limits one or more of major life activities of an individual, having a record of that and being regarded as having that. So we look at major life activities like walking, breathing, throwing, that sort of thing that we're tying in this idea that a person with a disability would be. So the qualified individual with disability is a person who, with or without reasonable accommodations, can perform the essential functions of the employment position. Reasonable accommodation, an employer, reasonable modification in the other aspect, with a facility or different types of sport that we're looking at, must make reasonable accommodations for the workers with disabilities, as long as it doesn't result in undue hardship. And we talked about that in a minute. We will do that again. Reasonable accommodations, making existing facilities used by employees reasonably accessible to and usable. We're not just talking about the facility, making the ramps and the bathrooms and doorways. We're talking about the job itself, such as job restructuring, part-time modifying, reassigning different tasks. If a job requires you carrying 35 pounds, but everything else is able to be done by somebody in a wheelchair, perhaps we take that 35-pound requirement, give it to somebody else and take one of their job tasks. That's what this reasonable accommodation means in terms of employment. It's not just creating a job that is discriminatory. It's looking into the major aspects, those essential elements of the job, and seeing what you can keep and what you can trade out in order to fit a position for a person with a disability, whether it's training materials or readers or interpreters, or we can look at, through technology, all sorts of job help placements and technology and equipment and computers that we can really make this reasonable accommodation fit people with disability. An undue hardship is covered when the act of the accommodation puts a financial undue hardship on the organization. Is it going to put the organization at risk? If so, then you don't have to make the reasonable accommodation. But again, this is going to be scrutinized by a court very clearly. And if it's not really true, the court's not really going to feel, they're not going to find in favor of you. The overall financial resources of the entity we're going to look at, number of employees, the composition, structure of the workforce. So we're going to look at really this undue hardship. There's a heavy priority not to accept it. So you really have to show that this is going to put your organization at risk. And then finally, last thing we'll look at is this McFadden versus Grasmick case that talked about Tatiana McFadden trying to get wheelchair athletics in a sport. Would that change the fundamental? Is there a reasonable accommodation to it or not?